Bismillah ar-Rahman ar-Rahim. How our universities and law schools teach Islamic law. Before trying to find an answer to this question, it is imperative to have a look at the approach of the universities and law schools to Islamic law. And when we try to do that, we come across some interesting terminology. If you are in the International Islamic University, Islamabad, you talk about Islamic law, Sharia, fiqh, and so on. But if you are in the University of the Punjab or in the University of Peshawar or any other law school for that matter, you talk about principles of Muhammadan law by D.F. Mullah, bin Shah Fardoonji Mullah. And students of law know that D.F. Mullah, a great lawyer in his own right, he tried to examine and analyze various decisions of the high courts and other relevant precedents to find out principles on which those decisions are based, and then to compile those principles in a codified form and then order them subject wise and section wise. That was a great effort on his part. But what the courts were doing at that time, if you just go back uh, and you look at the way the British colonial masters replaced Islamic law in the Indian subcontinent, you find that in the initial stages they were not interfering in what they called personal matters of the people here in this subcontinent. They were trying to avoid interference in those affairs. So, issues of marriage, divorce, inheritance, and the like were decided by the religious scholars and qazis who were trained in religious law, in Islamic law. Later, however, they tried to change the system. So, they, in that process of anglicization of law, and by the way, when several people today ask the question about the uh, reason for Islamization of laws, a very simple answer is that because the British masters anglicized the law here, we are compelled to Islamize it. Had they not anglicized it, we would not be compelled to Islamize them because the law would then evolve in its own particular way. Anyhow, when they were trying to anglicize the law, the first thing they did was that they replaced those qazis with judges who would be assisted by muftis or jurisconsults. In the second stage, they saw that these muftis uh, they try to find out rules of Islamic law in some specific books. For example, if this is a Hanafi mufti, he would look at Hidayah, a very famous Hanafi manual, or to Fatawa Alamgiriya, also called Fatawa Hindiya, which were compiled during the reign of Aurangzeb Alamgir, last of the great Mughal emperors. So these Britishers, they tried to translate the relevant passages and chapters from those sources. And then we had Charles Hamilton's translation of the Hidayah, or Bailey's Digest of Muhammadan Law. Interestingly, Charles Hamilton, whose translation of Hidayah is still used by our high courts and Supreme Court, Charles Hamilton did not know Arabic. And you know that Hidayah is written in Arabic. He actually translated Hidayah from Persian into English. There was Persian translation of Hidayah, and then Hamilton would translate from that Persian translation, he would translate it into English. So, what is available today to most of our judges in the high courts and Supreme Court, it is actually the translation of Hidayah. And Hidayah is actually commentary on Bidayatul Muqtadi. That is actually the text on which this commentary was written. There is an intricate system of understanding and approaching this law, uh, but uh, forget about those details And what we have today is that English judges trying to understand principles of Islamic law from translated works and then applying them into real life situations in cases before them. And the result was the so called Anglo Muhammadan law. And then Dear Mullah would go and would examine those judgments and would try to compile those principles and codify them and order them in the form of sections. And then we would have Mullah's court. And this is what Islamic law means to most of our lawyers and judges trained in those institutions. So the first thing they did to Islamic law, they confined it to some specific issues of marriage, divorce, inheritance, gifts, wills, and the like, the so called personal law. Interestingly, we have a law in our statute book which is called Muslim Personal Law, and in brackets they use Shariat. Muslim Personal Law, Shariat Act 1962. And there were several other statutes of the same title before this. But presently we have in Pakistan this law which is enforced now. Muslim Personal Law, Shariat Application Act 1962. Look at section 2 of that act and you will find a long series of subjects where Muslim personal law, that is Sharia, is the rule of the decision, but it is subject to law, subject to legislation. So in this way, Islamic law was reduced to issues of personal law. Had they used the Roman law concept of personal law, it would be a very wide area because in Roman law, subjects were either divided into, either categorized as uh, personal law or property law or law about acts. So, personal law or law about personal status in Roman tradition was also having a wide scope. But in Indian subcontinent, when they used this phrase Muslim personal law, it was specifically about marriage, divorce, and other related issues. Uh, Now, this is one thing. The second problem is the biases which we have inherited from our colonial masters, biases about Islamic law. And I will specifically mention three biases. One, when they talk about Islamic law and when Islamic law is taught in our law schools and universities, they approach to this law in this way. They feel and they have this preconceived notion and bias about Islamic law that it is a rigid law, out of tune with the realities of the time. It might have been beneficial in the past, but it is no longer relevant today. Also, it is religious law, so it is something which is quite relevant to Maulvis, but not to lawyers. This is one of the biases. And we should know that Islamic law governed the world for 1,000 years. And it is a very effective and very intricate and very detailed legal system. So we have to get rid of this particular bias. This is one. Second, because of the influences of Joseph Shah, N.J. Coulson, and others who wrote about Islamic law, people here in Pakistan, while teaching Islamic law and while reading Islamic law, they feel and they have this preconceived notion and bias that what the jurists recorded in the manuals of Islamic law, in the manuals of fiqh, it was only theory. And what was practiced in reality, that was a kind of non religious, secular system of administration. And there was a gap between theory and practice. In theory, Sharia, in practice, siyasa. So, siyasa and Sharia. This is how they approach the Islamic legal system and legal history. Although in Islamic legal history, when it is examined from the sources of Islamic law and its own tradition, siyasa and sharia, they were always hand in hand. And there was no siyasa without sharia, and that is why it was always called siyasa sharia, administration of justice in accordance with Islamic law. Anyhow, this is the second bias, that what the jurists have recorded in the manuals of fiqh was only theory and practice was different. We have to get rid of this particular bias as well if we try to understand Islamic law. Thirdly, and this is also very important, because of the influences of these scholars which I've just named, there is a, an assumption about Islamic law, and that is that despite several differences between Hanafis, Shafis, Malikis, and others, they had a common legal theory, and they only differed in details. Sometimes it is called classical legal theory. Uh, while the fact remains that every school of law was and is a system of interpretation, an internally coherent system of interpretation. How the Malikis, for example, approach Islamic law. This is a complete legal theory in itself. How the Hanafis approach the Quran and the Sunnah. This is also a peculiar system of interpretation, a complete legal theory. And the same is the case with other law schools. But what we have done here first, that we have negated these differences and we have assumed that they all were based on one common classical legal theory. And secondly, in our textbooks, which are used in various law schools in Pakistan and in various universities, these schools of law are called sects. And because we have developed a kind of aversion towards the uh, uh, the concept of sect, so the same aversion is then there about Hanafi, Shafi, Maliki, and other approaches towards Islamic law. Interestingly, we do not have the same aversion about natural law tradition, legal positivism, utilitarianism, economic analysis of law, and so on and so forth. There are so many approaches towards law in the West today, and the same approaches are being used by our judges and lawyers here, and they never feel any kind of aversion here. But when it comes to Islamic law and they see different approaches towards the texts of the Quran and the Sunnah, this is the Hanafi approach, this is the Shafi approach, they say this is sectarian difference. This is not sectarian. This is difference of interpretation. This is difference of legal theory. And that is why when people raise this question, there are so many differences and there are so many sects whose Sharia shall be enforced in Pakistan. My answer is very simple. Whose constitution is enforced in Pakistan? There are so many different approaches towards the constitution. There are so many different theories about interpretation of the constitution. Whose interpretation is then enforced? We have a system for that purpose. And in the same way, we have a system for resolving differences and conflicts in Islamic legal system. So we have to get rid of these three biases. Only then we can understand the true and we can appreciate the true spirit of Islamic law and its benefit to our system. Unfortunately, in our law schools and universities, Islamic law is uh, considered just as a law among so many other laws. Apart from the uncodified Muslim personal law, we have a few other pieces such as the Hudud ordinances or the Qisas and Diyat law, the preemption law, and a few others. So our judges and lawyers, they have adopted a kind of piecemeal approach towards Islamic law. In much the same way as they talk about Islamic provisions of the Constitution sometimes, as if other provisions of the Constitution are un Islamic or at least non Islamic. This should not be the case. Law is an organic whole, and this piecemeal approach is very defective. Consider, for example, Section 100 of the Pakistan Penal Code, which uses the phrase grievous hurt. One of the reasons, one of the grounds which allows a person to cause the death of the assailant acting in self defense. So, there the phrase grievous hurt is used. And we know that before the promulgation of the Qisas and Diyat law in the Pakistan Penal Code, we had two kinds of hurts, simple and grievous. These kinds of hurts have now been replaced by so many other kinds of hurts through the Qisas and Diyat law. So the phrase grievous hurt has never been defined in the uh, penal code, no longer at least. Now, what does grievous hurt mean here? Should we use the principles of English law, English criminal law for that purpose, or should we consider the principles of Islamic law? There is section 338F of the Pakistan Penal Code about interpretation of that particular chapter about Qisas and Diyat law, and it says that Islamic injunctions should be used for interpreting this chapter. Not only this chapter, but it also uses the phrase for matters which are ancillary or akin thereto. And one of the examples is the section 100. So while interpreting section 100, at least this section 338F makes it binding on the courts to consider Islamic injunctions while interpreting that law. And this is not only about penal law. We have the same clause about interpretation in the Preemption Act and in a few other laws, such as the prohibition of usurious loans act in the Khyber Pakhtunkhwa province. And then we have a general law in the form of Section 4 of the Enforcement of the Sharia Act 1991, which makes it binding on courts because it uses the word shall. It makes it binding on courts to interpret laws in accordance with Islamic injunctions. And unfortunately, our judges and lawyers ignore this law, and very seldom they refer to it. And sometimes when they do refer to it, they say that this section says that if two interpretations are possible, then the interpretation which is in accordance with Islamic injunctions shall be adopted. But as there is only one interpretation possible, so we will not look at Islamic injunctions. This is not the case. This should not be the case, because to say that there is only one interpretation possible, this in itself is an act of interpretation. This is in itself based on some assumptions, some presumptions. So, two interpretations are always possible, as Aharon Barak, president of the Israeli Supreme Court, had said in his famous book on the purposive interpretation. Two interpretations are always possible, which means that Islamic injunctions are always relevant. And more particularly because we are in Pakistan, where the constitution says that this is an Islamic Republic, Article 1, where the constitution says that Islam is the state religion of Pakistan, Article 2, where the constitution declares that sovereignty over the entire universe belongs to Almighty Allah alone, and that people of Pakistan and the government and all institutions here shall exercise their powers within the limits prescribed by Him, and where the constitution says that freedom and human rights and democracy shall be guaranteed, but there is a proviso there, a condition there, as enunciated by Islam. This is in the preamble of the Constitution, which is now operative part of the Constitution as per Article 2A. And then in the same Constitution, we have declared that all existing laws shall be brought into conformity with Islamic injunctions, and that no law shall be made repugnant to these injunctions, Article 227 of the Constitution. And we have the Federal Shariat Court, which can nullify a law if it is repugnant to Islamic injunctions. Now, with this background, and where the Constitution also declares that this is among the duties of the state to enable Muslims to live their individual and collective life in accordance with Islamic law. This is Article 31 of the Constitution. So, in this kind of system, Islamic law is not just a law among so many other laws. Rather, Islamic law is the law of the land, and it should be taught as such by our universities and law schools. Thank you.